Back, everybody. We're our last agenda item today. This is a workshop on public records request put on by our legal team. So I will turn it over to Arnie Oak, whoever's leading this one.
Yep. I'm going to lead the discussion, and Arnie's going to try to keep up with the PowerPoint. Appreciate his help with that part of it because his technology skills are far superior than mine are.
Good,
So-
Arnie, I need your help.
Who in the room attended the public records law training I put on last year? Some of this is going to be new. Some of it will be a repeat of what we talked about last year. But it's always good, in my opinion, to have a refresher in Public Records Act requirements and what you need to do as a public employee. So I think a couple of things that are new are, and I'm hearing this from a lot of counties throughout Idaho, is AI-generated public records requests are on the rise. It's going to become the normal part of your everyday job, I think, because it doesn't take a whole lot of effort and energy to submit a request like that, but it may take a whole lot of effort and energy to respond to it. So a lot of counties are seeing it, and typically they're asking for wide, very broad, very large amounts of information and data. And so I thought it'd be a good time to kind of have a refresher on the Public Records Act requirements, how we're going to prepare for these kinds of requests and make sure that we're complying with the law when we do so. So first slide obviously was put together. Go to the definition section, go to the definition slide. Maybe that's third in.
This is slide. Let's have the slideshow.
Sorry, it's a little clunky, but there it is. Public record includes but is not limited to any writing containing information relating to the conduct or administration of the public's business prepared, owned, used, or retained by any state agency or local agency, regardless of physical form or characteristics. Okay, standard legal definition. You read it probably 1,000 times and you never really pay attention to it until you got a public records request right in front of you and you say, geez, is this a public record or is this a responsive record, or how do I figure out? So how do I figure out how to do this? So let's start with step one. When you get a public records request, what's your first step? Didn't know this was going to be a test, did you? What's the first step?
Reply that you've received it?
Read the request.
Well, that
Just
too.
read.
Read
yeah,
the request, reply that you received it, read the request.
Make sure it applies to our department, not for them. It's the first thing we usually.
Ask for more clarification if it's too broad
Ask for clarification okay.
from the person that sent it. And then probably try to do a rough estimate of what it would cost if it's a very large request, and then let that person know what the estimated charges will be and if they want to move forward or not.
Okay, let's start with that right there. Is it legal? Can you do that?
Yes, because we have a resolution passed stating our policy on public record requests.
So you got that from our public records policy. I'll put you on the spot. It's okay. There's no reason to be nervous.
Well, it's
You're
a
amongst
recorded-
friends.
Nobody else doesn't answer
It's a
questions.
recorded it's a recorded document that the commissioners adopted.
Correct.
I would assume it's legal.
Well, it's legal if it's in the statute. Here's my angle. Here's my angle. Is that in Idaho code that says you can ask them clarifying questions on how to respond to their question or their public records request?
I would assume so, so you can get them the information they're looking for.
So-
If they're not clear enough in their description.
Okay, I'm gonna help you.
Okay, thanks.
Yes, that is in Idaho code. You know where to look in Idaho code to verify that.
7411.
Okay,
13.
that to me is the first step in being, if you're gonna be the custodian of the records, you need to know where the Idaho Public Records Act is, and you need to have that dog-eared, and the book falls open to that chapter because you're reading it so often. Title 74, Chapter 1 is the Idaho Public Records Act. You can see I've cited to it right there, 74-101's parent 13. That is where you will find the definition of what a public records is in Idaho code. You all know how to find Title 74. If you don't have the books, like right over there, it's on the website. So if you just Googled Idaho code and went to Idaho code 74-1, you will come up with the Public Records Act. Another really good, and I gave this out last year when I gave this training, another really good resource is the Attorney General's manual for the Idaho Public Records Law. In that manual has all the sections of Idaho code. And so a lot of the public employees that I've worked with over time, they've just used that as their reference manual for responding to public records stuff. But I was giving Sue a little bit of a hard time about, is that legal? Because there's some other things in there that you need to be aware of that you can't ask. You are prohibited actually from asking a requester why they want the information. So you have to be very careful, and you have to refer back to what you can and can't ask of a requester and what you are authorized to do. And yes, it is in our policy as well. You can ask them to clarify. So if they ask for 1 million pieces of paper and it just appears that they're just kind of doing the kitchen sink request to get down to, one particular issue, you can call them up and you can say, well, if this is what you're looking for, this is what we have, and you can help guide them to make it both easier on them and, but that's about it. That's about all you can ask. And so you do have to be careful about what you're talking about or what you're asking of a requester. So, Arnie, if you would go to this slide, the list of public records include. When I do this training, I don't get very far into my slideshow presentation because when we start talking about what is and what isn't a public record, I get a million questions. And I hope I get a million questions today because this is an important thing to talk about, and it's important for you to understand it as public employees. There is a definition or a statement from a court case, the Idaho Conservation League versus the Idaho State Department of Agriculture in 2006. That is an important part of the public records law. The attorney that handled that case was me, and I don't want to ever be in that position again because we did not have a good case, and we got smacked around pretty good by the courts on this one. And I'll give you just the down and dirty about what this case was about. For those of you who are familiar with agricultural operations, large livestock facilities are required to have a nutrient management plan. That's a plan for how they handle all the waste that is generated by their cows. That plan is usually some some type of a strategy for land, applying it to growing crops. So what the law doesn't allow you to do is just dump all of your waste product onto the ground and have a negative impact on the environment. It has to be somewhat precise. You're growing corn. Corn needs this much nitrogen. This product has this much nitrogen, so it has to be strategically placed. So the Conservation League and other environmental groups are always interested in, are you over applying or under applying? Well, the legislature said, the legislature enacted a statute that said when the Department of Ag reviews these nutrient management plans, they are going to return all of the documents that they reviewed back to the livestock owner. So the idea being, if we don't have possession of this document, then we don't have to provide it, or we can't provide it because we don't have it in our possession. It's actually in the livestock owner's files, not in the Department of Ag's. The court said, we don't like that. We don't like that at all. In fact, we think that anything that that a state agency or county government has access to, regulatory-wise, is also a public record. So stuff that was in the files of the dairy or beef feedlot was also a public record. So as you can tell, the definition is extremely broad on what is and is not a public record. So if you can get it, even if you don't have it in your hand or in your file, you are required under the Public Records Act to provide a copy to the requester. Now, how many days do you have to go get that document? Anybody know? 3 days.
Unless you file for an extension and notify them that it'll take longer than 3 days, and then you have up to 10
And is that calendar days, working days?
working days.
It's working days. So you don't have to count holidays or Saturdays and Sundays. Okay, just grab my phone. This is my phone. Bought it with my own private funds, but I bring it to work and I use it to email and I use it to text. So, and this is where I usually get the million questions. Hey, wait a minute. What? You're telling me that people are going to get access to my phone? Maybe. So, could you go back to the definition? Let's take a look at the definition of what is a public record, and let's try to answer the question about Oki's text messages. Are they a public record, or are they my own private, is that my own private information?
No, it would be subject, because it's related to county business.
And that's the key. So I'm married, and one of the common forms of communication between married people is they text back and forth. Are text messages between me and my wife a public record?
No.
What does it have to be a public record?
It needs to be associated with,
Conduct or administration of the public's business. So if I text Sue, are you coming to the public records training today? Is that a public record?
yes.
Yes. So that text message is a public record. And, in 2003, when I started working for the state, texting was really not much of a thing back then. People used email a lot like what people use text messages for now. And so the training was always focused about be really careful about what you put in email, because people were sending emails back and forth, and it was less formal than a letter. And so it became much more prone to say things or say something that was maybe not very professional. That's the problem with text messages and other social media apps today is you're texting faster than you're thinking, and say some things that you may not want to be out there, so be careful. Be careful.
Brian, I know with a lot of public records, there's retention schedules that we're supposed to keep with them. What about texting? Is there anything like, if you do use your phone, your work, or your personal phone, or even your work phone for texting, would I have an affirmative defense if I said, I just delete texts all the time?
You should retain all public records consistent, and I'm glad you brought this up, Mike, because this is an important part of this training, is that for every public record, we should be following the records retention policy for emails, for text messages, and for paper documents that we're creating. And I always try to emphasize that, because when you get a public records request that it basically says, I want everything, one way that you can manage the size and the scope of that is that you're following your records retention policy and you've disposed of things that you are no longer required to keep, and then you just produce what you have, not what you have disposed of. I can't tell you just sitting here what the records retention policy says about emails and text messages, but you should maintain or retain those consistent with the records retention policy.
That's Jeremy that once, he said all that stuff is still on the server.
Probably is. If it's ran through the server,
Ran through
your emails certainly are, your text messages.
So emails and texts, even if you delete it, it's still on the server.
My text messages are, I mean, that's between me and Verizon, who's my carrier. So text messages, I don't think goes through our server, but certainly our emails do.
Yeah, definitely.
So if someone does a public information request and wants to see all of your emails, it's said developer, they need to specify which developer. They can't just say, I want to see all of your
Yeah.
personal emails.
A request like that, Cindy, would be the one where you'd want to call them up and say, I need more information, or clarify exactly what it is that they're trying. And you can talk to them about that and kind of pinpoint what we're.
What it is, but not what.
Right.
That's the key.
Yes.
You can't ask what.
So let's talk about large volume, high labor public records request response. Somebody asks for, I want everything historical on a particular topic. But you're busy. You got lots of other things going on. You have other priorities and you have other responsibilities that you have to do that are well in advance. What exactly?
Oh, no.
You have to make the public records request a top priority.
Tell them no, don't open the email. I haven't
It
heard,
says how long it's gonna
go
take you and
home,
let them
go
know.
home sick. Haven't heard that one yet.
I
I have
have
used
file
that
extension,
10 days
right, so you can get it up to 10 days, and if you need additional days, can you file it with a second extension, so I'm assuming there's
Yeah.
extension time, right?
You can, except for, I want to focus in on the 3-day response time first, and then we'll talk about those next steps that come after that. The public records law is very unsympathetic about what your workload is or how inconvenienced you are. This is a law that can be, let's be honest, it can be a real pain in the butt to have to implement and do, but it's one of the most important things that we do. This is how we are transparent with the public. This is how the public sees how their tax dollars are being used. And so there is no excuse for not complying with, at least as far as the statute goes. You have 3 days to respond. If it's going to take you more than 3 days, 3 working days to respond to the public records request, you still have to respond. That response is, we're working on it. It's going to take us more time. And we will send you a response within 10 calendar days from the date of receipt. But you are required to do that within 3 working days, even if you're not giving them copies of documents yet, you're telling them, we received your request, we're working on your request, and it's gonna take additional time. Question?
Often if the request is when you're on vacation or.
Good question. What's your plan? What do you do if you're on vacation?
Checking my emails or not?
I usually forward it on.
Yeah, cause if I'm gonna be out, and I definitely am, I'm out, I'm not working. I usually have an auto reply on if something, please contact the office, and I'm hoping if they need something right away, they're gonna contact the office.
We
Or
have,
whatever.
we have ours set up to go to the front office. So anybody working in the front office will see the public records requests come in.
But there's some things that we aren't able to run.
Right, but
That.
he's talking about what if you're gone on vacation for 2 weeks and somebody puts in a public records request the day after you leave?
Yeah.
So,
So here's what the law says. It's 3 days, you have to respond within 3 working days from when the request is received. So, right. And this is something that we really need to have a plan for within each department, because public records law says every custodian of the record needs to, or every department that has public records needs to designate a custodian of those records. And the custodian is responsible for receiving public records requests, responding, correctly to that. And if you are the custodian of the records, Lori, and you're on vacation, then you probably needs to be a task that needs to be delegated while you're out of the office and unavailable. So we don't have these public records requests sitting in these email inboxes and they don't respond. So I think it's up to every department to figure out how to manage that correctly, but you do need to designate a custodian. That needs to be a task assigned to that person. And then you need to implement a policy on how you're going to respond to requests if that person is sick or on vacation or is not.
How do they
So
get
if
that?
you, nowadays, can public records requests be done electronically, or does it have to be on paper?
It can be done electronically. And that's
Either.
outlined in the policy. I think the best way to do that is to have an actual like an electronic fillable form that's available on the website. And you ask for all the information that you need to correctly respond to the request, and then I would redirect people back to that. Because I always get that question right there. Because I used to advise an agency that had 300 plus employees. And so, every one of them was like, well, when I'm on vacation, how am I going to respond to a public records request? And we always set up a specific public records request email account with a fillable form, and there was redundancy within each department. So if Lori's on vacation, Cinda sees the email, or somebody else will always see that email, and then you have addressed that issue. And that's the way I would recommend that each of you do that, is use a fillable form, have a specific account. It's not Lori Hunter's email account, it's the Valley County Planning and Zoning Public Records email account, or Valley County email account. Seemed to be the best way to make that work.
So each department has their own form for public records, so we have to create our own form, or is there a generic?
I think one form for each department for the whole county would work perfectly fine.
so the assessor has one and it's under the assessor tab. But I think Tamara can, or you guys could work together on what questions you want
I
to
do
ask.
think that's probably something that we should consider, having a uniform form, because we have multiple forms.
Yeah, let's pull all of the forms in, let's pick the best one or modify the forms to So we have one, and then make them available to all the departments, so we can be uniform in the way that we do that. That is the simplest way, and that at least.
Are you gonna do that, Artie?
Right. That at least will address or deal with the problem of public records requests sitting in somebody's email account, and they didn't see it or didn't know about it.
Can we still charge for these requests?
Yes. We just adopted the policy, the public records policy that allows for us to charge after the first 2 hours and after the first 100 pages, there is a charge that is associated with that. Back to this slide.
So who's gonna come up with the one form fits all?
I think we have a form, Cindy, and it just has clerk, assessor, it's the same form, it just has different titles of who it's to be addressed to. I think what we need to do is eliminate that. I don't know, I think it's probably further discussion needs to occur. Or we can,
We'll wait till somebody decides and then we'll decide.
again, I don't think anyone is, ultimately it'd probably be a decision from the commissioners, what form they want us to use. Right now, I think planning and zoning has a form, not, okay.
I know like the assessors and the clerks and sheriff's office, maybe you
They
go
do.
online and do a form.
Yeah.
We do not have that.
And I think we'll work with IT, at first probably present it to the commissioners and say, hey, this is a procedure that we've developed. This is something that the commissioners are willing to approve. That would be my proposal, but
Sounds like a plan.
Okay.
If you have an
Fire away.
Department of one, when I leave, can I assign or ask another department to oversee that kind of thing? No.
I
That means you can
Just
never
ask.
really.
Just forward it to Sherry.
I'm sitting here thinking now, what are we gonna do when you're gone?
Yeah.
Because Mike has the same issue.
Yeah.
I bring my cell phone with me anywhere I go.
Just in
I
case.
do
You don't have service.
Don't do that.
My work cell phone.
Have to.
Right. So those are tough. I mean, I know you're just, I think it's really bad to have requests for information unresponded to in somebody's email account. So I always recommend and I prefer redundancy. I know that's gonna be tough for you to implement, so there might need to be some thought and
I
effort.
put my files in a couple different spots for that reason. So it's all on these are on the drive, so that. There's a few discussion of who I should reach out to.
I haven't got the database question yet on public records, because you should know also in our policy and in the law too, you are not required to create a record in order to respond to a public records request. You're giving copies of what is in your file, existing records. You don't have to create one. So I always get a question about database because how databases work. That is just a big jumbled up mess of data that's in a database, and you have reports that you really formulate based on the type of report you want to run. You ask the database to compile it and then print it, and I always get the question, are we not creating a record related to database? And over the years, I struggled with that a little bit. I don't struggle with it anymore. If you can create a report from a database, then create the report, print it, and send it to your
Get that a lot for
requester.
subdivision,
Yes.
current owners for subdivision.
Yeah. If the software is capable of printing a report, then you should file it. So,
So Oki, you're saying, report, we don't have to have a public records request.
no, you should be responding to a public records request.
Okay, so the agencies that ask do they have to provide
submitted. No. No, no, if you have a data sharing agreement with another agency, then I don't consider that a public records request. Okay, this slide, we've already covered this. I put this slide in there specifically to give you the information where you can go to find the Public Records Act. Idaho Code 74-101, that is your public records statute. That's where you go to find the public records law. Why is it important to know where the public records law is?
Because you need to read it when you get a public records
That
request.
is the law that's going to tell you whether or not you can provide what's confidential and what's not. There's a fairly lengthy list of sections of what's exempt from disclosure. One of the most important things you will do in processing public records requests is to be able to identify what needs to be redacted and what needs to be left in. That's where Arnie and I can help you with that. We've got a lot of experience with this. I've done a lot. Arnie's done several since he's hired on here and has a career's worth of experience under the federal FOIA. So we can certainly help you with that. Don't guess at this. This is one thing you do not guess, because we have access to information like Social Security numbers and other private confidential information that we require the regulated community to give us that information. And there is a set of statutes in the Public Records Act that says if you get a public records request, this type of information is exempt. So we don't want to process these too fast and give out confidential information like I said, like Social Security numbers, a bunch of other things too. Trade secrets, private business confidential stuff. So that's why I say you need to be familiar with where to find this in the law so you can review the exemptions that are listed there and determine whether the document that you're going to provide has exempt information that's contained within it. So how many people are familiar with that process of redacting? Have everybody here done that? No. Yes, no. So if you have, let's say you have a full sheet of information and you find somebody's personal cell phone number, their personal address, and their social security number is contained within that, what's the steps or the processes that you use to deal with that? You just pull the whole sheet out, you black out the social security number. Yes. Yep. So you redact. What's your process for redacting? Does everybody have Adobe Pro, or do you use the old-fashioned black magic marker?
We don't all have Adobe Pro. It would be
So-
certainly helpful.
Yeah.
In fact, it's kind of on my to-do list to
Yeah.
request that.
IT doesn't like to look at us all have Adobe.
No.
So you're still using black magic marker. Have you all noticed, like I have, when you take a document and you black something out and you look at it right there, you can see right through it.
You have to go read it,
So-
you have to recopy it.
So you've all heard me say, you got it. If you do that, then run it through the copy machine and then send the second version of that, not the first, because you're still disclosing stuff.
If you have not Adobe Pro, but normal Adobe, what I used to have to do is I would, on the PDF, I would text box it over in black and then print it to a PDF.
And that works.
That worked. But usually it would turn all the paper sideways. I don't know why, but it would work.
It's all very time consuming.
It is definitely
Very.
time consuming. Adobe Pro is much nicer and quicker about it. It's still just time consuming.
Thanks. Like I said a few minutes ago, the Public Records Act is so unsympathetic about what a pain in the butt this is for you and your life. But it is, like I said, one of the most important things we do as public employees to be transparent with our constituents. But yes, public records, and this is what's tough about it, is you don't come to work on a Monday morning thinking that you've got this public records, because usually it's waiting for you, and that's, you have a long list of other things that need to be done, and now all of a sudden it's gonna take, you have to reshuffle the deck. So, that's just the reality of it, and a lot of the requests are substantial in size, so.
Has anyone gotten a reason that you all don't have Adobe Pro?
Cost. I'm the only one in the P and Z that has Adobe Pro, and that took a few years and helpful from the prosecutor's office for me to get back.
The question of what is the definition of this? Somebody else?
This question about what is received, what does it mean when a public records request is received? So, it's more of policy, this is more of a policy, I guess, than it is, because there isn't a legal definition of what that means, but if somebody submits a public records request on Friday night at 12 o'clock at midnight on Friday, you're in the hole 2 days already when you get to work on Monday morning, if it was received when it was sent. And so I never say it was received when it was sent. It was received when it was opened.
Monday morning at
Monday
8
morning,
a.m.
Monday morning at 8 a.m. When it was
Didn't you say working days?
Say working day,
Yeah.
that would make
From-
sense.
Yeah.
we're-
So bad example, but yeah. Tuesday night at midnight, and you're on vacation on Wednesday and Thursday. So,
It's a holiday.
but yes, it's received when it is opened. So that's why and if you were at the training last year, I tried to distribute my form letter, and my form letter in acknowledging that you received a public records request it always will catalog all of that information. It'll say, on such and such a date, I received your request for, and the date is the date that I clicked on that email and I opened it and saw this is a public records request, and that starts the clock. Any other questions?
So you don't click on it for a while.
If you're actively, man, you're gonna be hard. Hard in this one.
Triage your emails.
I mean, that is a component though for like me, and like if I'm gone, and someone else doesn't have it, is that truly the case though?
Yeah.
Like,
Yeah, it is. If you're gone and you
legally
didn't,
it is.
yeah. So this slide kind of covers some ground that we've talked about up until now, but I threw it up there anyway. No request is too broad or too burdensome. Kind of goes back to the need for you to do a records retention analysis to make sure that you're not keeping stuff that you're not required to keep, you're disposing of it with the records retention policy. I've had extremely large requests where they just insisted that I want to see every piece of paper that you ever created and you have kept. And just like most people, we had a whole bunch of paper that we had taken out of the regular filing cabinet and put into banker's boxes. The banker's boxes went out into the storage shed, and everybody forgot that they were there, and they were records that were created 75 years ago. If you can imagine the pain that it is it's like, well, we knew we had all these records and went out in the storage unit, got the banker's boxes out and went through them page after page after page and pulled out the ones that were responsive to the request. And it's because we were keeping them, and we had access to it that we had to provide it. So it took a ton of time to process that public records request because we were not following our records retention policy. But they could be, you could have 2,000-page request and you're required to respond to it.
So I have a question. So I know the Idaho State Tax Commission has a retention policy for like assessment records.
Mhm.
But does the Valley County have one as well? We
So,
did.
yeah, the commissioners adopted the Idaho Association of Counties Record Retention
Okay,
Manual. That manual is in my office, but I can make sure that that's readily available to all departments.
okay. Is it electronic or?
I don't know if we have it electronic, but I can scan it in.
Okay.
So to make it sure it is electronic.
I think that might be pretty
It
awesome.
has it broke down for each department.
Nice. Nice.
Except for yours.
Next slide on custodian. Okay, we talked briefly about this. This is a requirement of the Public Records Act, so I did put it on as a slide, and I wanted to just kind of emphasize this. Bullet number 2, a public agency shall designate a custodian or custodians for all public records, which includes any public official having custody of, control of, or authorized access to public records, and also includes all delegates of such officials, employees, or representatives. Hold that, I just copied and pasted right out of the Idaho Public Records Act. You're all getting very familiar with what those numbers mean, 74-102, Idaho Public Records Law. Basically, what that requires is that each department needs to have a designated custodian. And that custodian is now tasked with, and it is a job duty to be responsible for responding correctly to public records requests. Any questions about that?
How you gonna do that?
That'll be easy. That will be easy. That might present some challenges for you as a county commissioner, because you also are generating public records and you need to designate a custodian.
Sherry.
A second.
No. Denied.
The agenda.
That way,
No action item.
right, that way we have some process to, that's formalized, that helps us identify where we're gonna go to get the documents and who's gonna gather them up and provide them and process them.
Aren't we all responsible for our own? I mean, we don't really have anybody.
That probably makes sense for you as commissioners, that you just have to be responsible for your
I've copied my
documents.
social media posts.
Nah, that doesn't work for me. Sherry should do it.
I think so.
I don't think I've ever had a public.
Oh, wait, I'll take part of your salary.
Yeah,
And then I'll-
emails, I mean, obviously, emails are a big part of public records requests. And so when people want to see documents, a lot of times, most of the time, they're going to want to see emails. So, so you need to be retaining those emails consistent with the records retention policy and be available to provide those documents that are responsible. So and it's not uncommon for a requester to be crossed about. Nothing's ever easy. No one's ever going to just say, well, I just want to see the building department's documents. It's usually, if there's a public records request in the building department, it might also include planning and zoning. It might also include the 3 county commissioners. It might also implicate the clerk. So there has to be some level of collaboration, and having a custodian assigned will help in that process. The custodian for each one of those departments will be the person that you want to contact and say, hey, I just got this request. Will you check and see if you've got any documents that are responsive to this request and share it along? So, well,
The only thing I think maybe you covered and I missed it, but if it's over a certain number of hours, 2 hours or more, then you can get compensated at that employee hourly rate, whoever's doing it.
first 2 hours of labor is free. The first 100 pages is free. Beyond that, there is a charge. So the way that you calculate the labor rate is it's the lowest paid county employee that was involved in processing the public records request is how you calculate the labor rate. That's in the statute, and that's also in our policy.
Whoever's fulfilling the list.
Yep, when you respond, there's 2 ways to do it. You can require payment up front, or you can send them the documents and say, please remit X, whatever the charge is, and
they need to
Valley
pay.
County.
Valley County.
Just Valley County.
That goes,
Civic.
that goes to the general fund. So.
Quick question on that.
Yep, go ahead.
So I had one that came in that was a huge request. And so, I emailed them back. I think I might have asked for some clarification. So I referred to our, resolution 24-04, I think it is. And so I did an estimate of what it was going to cost, emailed it to that person. And then, so it was like, I emailed it to her on a Tuesday. I didn't hear back until Thursday from her, wanting to modify the request, asking what the new modified estimate would be.
Right.
And then so forth. I mean, so I guess the question is, as you're trying to give them this information and they're trying to decide if they want to move forward with the request or not, what does that do to your time clock?
Well, so let me take this in chunks, okay? So the first part of that process is, and it kind of relates back to the question I got before your question, which is how do we pay or how do we charge them? That's the preferred method, or that's the method that I think has worked the best in my experience, is you get a large request that's going to require more, that's going to trigger the cost. I think the best way to go about that is respond back to the requester and say, we've got an estimate of the cost, and you need to pay the estimate before we start processing the public records request. That almost always is going to take you beyond the 3 days, because there's all this back and forth, and a lot of times, because there's a charge associated with it, the requester wants to modify the request. Because like, well, I don't want to pay $50 for this, maybe I can narrow it down, and that's the whole idea of working with them, is to give them what they're looking for, and it isn't going to cost them anything. So that's allowed. What the law says is that you have to respond within 3 days. I've always advised my clients that if you've responded back saying, we have got your request, here's the estimate of the fees, you have responded. You have met the requirements of the statute. It doesn't require you to complete the response. You just have to respond within that 3 day period. So you've met the time deadlines. And that kind of goes back to, Mara, you asked a question a little while back about these large public records response is going to take more than even the 10 days. Same answer. As long as you are working with the requester and you are going back and forth, you're corresponding, you're meeting those timeframes. And I've had to respond to a request that was just physically, it was impossible to even provide every document within the 10 working days. It took us almost 10 months to provide all the documents. And so we negotiated a plan. Everybody was on board. They knew they were going to get the documents. It was going to be over an extended period of time, and it worked. So that is how I interpret this statute. What other questions?
Say we have completed a request for somebody, 10, 15 days or whatever. Somebody else comes along and wants the exact same information. We already done all. First people were charged.
Right.
What about the next entity that comes along that we've already got it?
Yeah.
Get it to them easier. How
Yeah.
is that?
Well, I mean, the law and the policy just basically says how much labor did it require for you to process the request. And if you have already redacted everything and you were smart to keep a copy, always keep a copy of what because you're going to get you might get a follow-up response, a request for the same or the similar. It might be unfair, but if it's less than 2 hours, it's free. And if all you had to do is take that stack of papers, put it on the copy machine and run another copy, then, yeah, it's not gonna take you 2 hours, so you don't.
The
so you
kicker
don't
is when
charge.
you get a similar request. So in our case, the applications for the last 6 years and then, so that's all in one file or zipped up. So if they ask, the next one asks for the last 3 years, I mean, you'd have to go in and modify that file.
Well, and you should always be keeping a copy of the stuff that you provide, just because there's always a chance that, I mean, there's always a chance or a risk of litigation, and the litigation in the public records context is gonna be, I asked for this and you didn't give it to me, or you only gave me part of it. You wanna have a copy of what you provided, and keep that copy at least for 180 days. The 180 days is the appeal period for Public Records Act time, so keep a copy. So, hand up.
So your 100-page, I assume it's this standard that we have. So
Yep.
if you wanted, 300 report, it's 56 page. Question for you, if it might electronically, is there still
Not per page, per labor hour to process, there might be. Yes. Any other questions?
Back to that really quick. So if we have to redact it and then run a copy,
Then you charge
okay,
per page.
okay.
Yeah.
And per hour.
Yes, yes. Yep, good clarifying.
And all the public records have to go through visual, like they get one, so like if you do that.
So
information.
the responses that do not require any redaction does not require legal review. If you have to delete or redact something, then it does actually require. So in my standard cover sheet, there's a paragraph that is set aside specifically for my initials or Arnie's initials, and will cite to the section of Idaho code that we have justified the redaction. So if you're redacting documents, then the law does require, well, let me clarify. You have one of two options. You either certify that you had the opportunity to consult with the attorney's office and you chose not to, or you did and I initialed. If you choose not to consult with this, that's up to you, but obviously the penalties it's all on you.
So you just want us to email that to you and then you guys can forward it on, or?
Typically, what we will do is we will review it and then send it back to you, so you can send it to the responder. All right.
Okay, a common request would be an application or, something along those lines out of the files, which I'll redact, phone numbers, emails, etc. And often, like nowadays, we put that redacted information on the website. But that's a common request. I just do that and I send it. I don't think that I need to go through legal that I'm redacting this information off an application. Right, that's a very
So-
common request.
Well, technically, yes, you have to do one of those two things. And the sheriff's office gets a lot of the same stuff too. And so they have created just kind of this form response that says they had the opportunity to consult and they chose not to. And I'm okay with that for those common responses, but they took the language right out of the public records law, and I'll send it to you if you want, Corey. And another appropriate response, if you have already put that on the website, is just to redirect them to the website.
Yeah, but then you get people who say, "Oh, I don't have a computer, I
Oh,
can't find it, blah, 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 blah."
You're, okay, I get it. So, but yeah, to technically be in compliance with the statute, you have to indicate that you chose not to consult with.
That'd be great.
Okay, so we've gone over the Public Records Act policy, 3 working days, 10 working days. This is new for 2024, bullet number 3. Just went into effect on July 1st. If you get a public records request from a non-Idaho resident, you have 21 days to respond instead of the 10 days with an extension. So it gives you a little bit of extra time.
I don't know if they're
I don't know. I think the best policy, I think best practice is you get a request, you process the request, you provide it to them, whether it takes you 1 day or 2 days. Don't wait 3 days or 10 days or 21 days, just process it. The legislature just said, we'll give you an opportunity to prioritize your response time for Idaho residents in the law. So you do have a little bit extra time there. Next slide, I think we might, hang on.
Listen for an accent mark.
I think I've been jumping ahead of my slides, obviously. Partially exempt documents, we're all familiar with that. Redaction process. Bullet number 3, what if they show up and want to look in your file? What do you do?
Always just let them.
Well, everything we have is public record.
Well,
I mean, but there's.
so any, like, for commercial properties, any income and expense information they give us is absolutely not a public record. I think you'd have to review it before letting them look at the entire file.
So if it's information and documents that you're familiar with and you know that there's nothing confidential there, there is no reason not to be accommodating to somebody coming in and wanting to see that. If you have any questions whatsoever about that file containing confidential information, politely tell them, fill out the form, we'll submit the request, we'll respond within 3 working days. That gives you the time to process it, consult with the prosecutor's office, and sometimes they don't like that answer, but that's the best advice I can give you. Because you have, like I said, you not only do you have to comply with the response time with the public records law, but you also have a duty, and a very important duty, to maintain the confidentiality of some of the data that you do have in your files. So they should be processed carefully and make sure that we're not disclosing confidential information.
Like if they send in a copy of a canceled check to prove that they got
Right.
paid for their agricultural use. Yes.
But we
Circuit
have to get
breaker stuff.
requests for recorded documents. with the county, so we have to review those before we send them.
Report, like what
Well,
time?
Deeds,
Well,
That's
there's,
the big
if
thing,
there's
remember.
birth or death certificates, you need to redact that, the personal information.
It could, yeah. Potentially there's redactable information.
Sometimes on deeds, there's social security numbers.
Yeah.
That's really.
Yeah. On death certificates and stuff, though, don't they, those are
Mhm.
all blacked out now, don't they?
They are.
Common exempt information, obviously you've got social security numbers, personal cell phone or personal addresses. There is some business confidential information that we collect. And so those are some of the common ones that we see quite a bit. Lori?
Sorry, you emphasized personal, you did it earlier. How about a business, a surveying company, engineering company?
Business emails, business phone numbers, and business addresses are not exempt. Those can be disclosed.
I mean, every deed generally.
And
has
sometimes
an
it's hard to
address that goes
it's
along
hard to
with it.
distinguish between the two.
Yeah.
If
It's
it's
not-
obvious, I can,
Yeah,
okay.
yes, commercial, like, yes, business data is not exempt.
So if I understand you right, you can't just let someone come in and
Or personal email.
They have to do.
Yep.
And
That's
let us redact.
right. So I'll repeat what I said so everybody can hear it again. If it's data and information that you are confident and comfortable with, that there isn't anything on there that's confidential or needs to be redacted, you are okay to share with the person that came to your door. If you have any question at all, if you are concerned about should I redact or not redact, best practices are to ask them to fill out the request, and that gives you the time to review that, consult with legal, and make sure that you're not disclosing something that you shouldn't be disclosing. So err on the side of caution. If you have any question at all, just politely ask them to fill out the request, and then you'll process it and send it to you. Or they can come back and pick it up.
If they wanna just then they have to file
That's typically the process. I mean, it is okay to, instead of, a lot of people do this now because we've got cameras on your phones. Instead of paying the copy charge, they just want to take a picture of it, that's fine. But if it's a public records request, you should have, if they're asking, yeah, you should have them fill out a public records request.
How can you prove what you gave them if you don't have that file in
That's,
order to prove it?
that's,
Because somebody can go right to somebody else and you're gonna get that call if you disclose my personal information. We have to be able to make sure that we can document, no, we didn't. Just protect ourselves.
yep.
So,
Process.
Go ahead.
question. Idaho being a non-disclosure state, our office will send out sales verification letters asking for them to tell us what they want to call the report. That couldn't happen. If they return that to us, tell us how much they paid, we couldn't do that.
Wrong. Probably. That's probably exempt, yeah. Now,
Well, we get those calls all the time.
to process a public records exemption, you have to be able to point to that section of Idaho code that says you shouldn't be
Depends on
providing
where we
this
got the
information. You
information
always
from.
have to cite to
We
a
get it
specific section of Idaho code
from, or did we get it
to
from-
justify redacting or
Sit on-
withholding information, which is also why the statute says you should be consulting with your legal counsel if you are redacting confidential information, because you have to do two things. Bullet point number 4, requester's right to appeal. That is also a mandatory in the response. If you are either withholding information or redacting some information, you have to give them notice that they have the right to appeal. So I've created that in my form letter, and that's the second component of consulting with legal and disclosing that they have the right to appeal the exemption.
Brian, who did the appeal to?
District court.
So they would have to set a court date and all that stuff.
Yep, they file a complaint with the district judge, and we go through that whole process, and then you have to be able to demonstrate that you were justified in withholding the information pursuant to the exemptions that are outlined in Idaho code. Civil penalties are there. I always put this in there to try to scare you into compliance. Civil penalty for not following the law or policy is in the Public Records Act. If you deliberately or in bad faith improperly refuse a legitimate request for public records, the court can impose a $1,000 civil penalty. So you don't want to do that. It might cost you $1,000, but again, I've tried to emphasize it. This is really such an important part of what we do as public employees: be transparent with the public, make sure that we are following the law the way it's outlined, and you have nothing to worry about there. So we've gone past an hour. Are there any questions, follow-up questions? Any horror stories you want to tell about public records requests?
Always chocolates, we're going over an hour.
I'm sorry. That was rough. Public records training should only be 59 minutes, not a minute more, not a minute less. Thanks for your time. As we progress into these kinds of trainings, I think I will start diving a little bit more in depth in the public records exemptions. We'll start talking about specific exemptions that might apply to some of the documents that you have, and some tricky ones that as you might expect, they're never easy. They're not completely black and white. So you do have to make some judgment calls sometimes on what to delete, what not to delete. We can maybe our next training will be, we'll call it Public Records 2.0.
So can I have the last question?
Sure.
So should we be redacting things we give to the P&Z Commission? Like
When,
applicants' phone numbers and,
like redacting it when you're giving it to the P&Z
they submit an
Commission?
application to us and then we give those applications
No.
to the P&Z Commission.
No, but I think you need to advise the commissioners that there is some information here that is confidential and that it's not to go beyond them. They're, I mean, even though they're volunteers, they're not paid, they're still county employees in essence. And so they're under the same obligation to keep confidential information confidential. And if they get a request for information, it really needs to come back to you, Cinda, to go through your custodian in your department to process.
How do they destroy their packets? They just leave them on the desk with
You gather them back up. Okay,
burn them.
Mostly.
We good? Good?
I think so.
Email.
Yeah, those on YouTube, this being the last item for the day, this meeting